Good afternoon. The Metropolitan Government's Board of Zoning Appeals meeting is now in session for its regularly scheduled meeting of November the 2nd, 2017. My name is John Michael. I'll be presenting the cases to the board for their review today. Here at the outset of the meeting, we would respectfully ask everyone to please silence your phones, your tablets, or any other electronic devices so that the board's proceedings will not be interrupted. Time is limited for each presenter, and we want to respect that. For each of today's public hearings, the board reviews the correspondence that's been submitted in support of and opposition to the cases. The board also reviews correspondence and recommendations from other government agencies in preparation for these hearings. In today's hearings, the staff will present the site plans, maps, photographs, and other documents that comprise the case record. At the conclusion of the staff's presentation, the appellant will present his or her case to the board. After the appellant's presentation, the board will hear from many of those who wish to speak in support of the appeal that's been presented. And then after those parties have spoken, the board would hear from opposition, if in fact there is any opposition present. Upon completion of presentation of testimony from the opposition, the appellant will have an opportunity to present rebuttal testimony if he or she wishes. Under BZA rules, an appellant has 10 minutes for a presentation if there's no opposition present. In contestant cases, BZA rules presently allow for 15 minutes for each side to present their testimony. Should the appellant wish to provide rebuttal testimony, save some portion of your originally allotted time to do so. At the conclusion of each hearing, the board will deliberate and then vote on that case. The board is vested with the power to act on each of these cases pursuant to the terms of the Metro Zoning Code, specifically Section 17.40.180. All of the section numbers that we refer to today come from the Metro Zoning Code, which applies to the entire jurisdiction of the metropolitan government. The Zoning Code was adopted by the Metro Council and took effect on January 1st, 1998. I will introduce the entire Zoning Code and make it part of today's record for each of the cases brought to the board. The Metro Code requires a record of these proceedings. Because BZA meetings are recorded for television, it's imperative that anyone addressing the board come forward and speak into one of the microphones here at the front of the room. Introduce yourself by name and address, and then make the desired presentation. The Metro Code also requires 4 of our 7 board members in order to establish quorum. The code requires at least 4 affirmative votes in order to grant an appeal. In the event that only 4 members are present for a case and an appeal fails to receive 4 affirmative votes, that appeal will be re-advertised for the next available public hearing. In the event that 5 or more board members are present and the appeal fails to receive 4 affirmative votes, the case will remain on the board's agenda for the next 30 days. Applications that fail to receive 4 affirmative votes within that 30 days from the original public hearing shall be deemed denied by operation of law. Pursuant to board rules, an aggrieved party may appeal any decision of the board to the Chancery Court within 60 days of the hearing date. Additionally, an aggrieved party may file a motion for rehearing within 60 days of the original hearing date, pursuant to the terms of the BZA rules and regulations. After that time, the board's decision becomes final. No further action can be taken. For the appellants, if your appeal is granted, you are in fact required to obtain the permit for which you've applied. A permit must be obtained within 2 years of the board's approval date in order to remain valid. After such time, you would have to reapproach the Board of Zoning Appeals for new approval. It should also be noted that if false or misleading testimony is presented to the board, any board approval or action could later be revoked by means of a show cause hearing before the BZA. Mr. Chairman, I submit that all the cases have been filed in the proper order, all appellants have been notified by certified mail, and all legal notice requirements have been fulfilled for today's cases. A few preliminary announcements from the docket for the board and for the public as well. 2 cases originally docketed have been withdrawn, namely Case 2017-178, involving property at 105 45th Avenue North, is a case that has been withdrawn by the appellant, and Case 2017-262, case at 4204 Hood Avenue, has also been withdrawn by its appellant. 2 cases have been deferred to the November 16 meeting, our next board meeting. Those are case 2017-230, involving the property in Whites Creek on Old Hickory Boulevard, at 7435 Old Hickory Boulevard, and case 274, involving the property at 2926 Foster Creighton Drive. Both of those will be deferred at the request of their appellants to November the 16th. Additionally, the show cause hearing that was set for case 2017-183 will be deferred indefinitely as the original appellant has decided to withdraw the permit application at issue. Therefore, the show cause hearing need not proceed at this time. However, we will flag the permit application accordingly and leave the show cause hearing indefinitely deferred in the interim. Mr. Chairman, as you know, we use this opportunity at the outset of the meeting to recognize our elected officials who are present. We have a number of council members with us today, and out of deference to ladies first, I believe I saw Councilmember Jacobia Dowell in the audience. Councilmember Dowell, do you wish to address the board at this point?
Thank you. I just want to come back. I'm here to speak on 2017-205. I asked for you to defer it until today so that the applicant could have an opportunity to speak with her board members. And I want to say that I have met with her. I have spoken with people in the community. I've talked with her board, the attorney with the HOA, and everyone else, and they're still in opposition to this. They have submitted letters, and I have copies that I will leave here today with that. Because of the neighbors do not support this, and also because this community has restrictive covenants that have been very clearly outlined to neighbors in the community, and people in the community are under the understanding that they are not allowed to have short-term rentals. And I know they just hired a new management company, a new board, and they're looking at it as a community to see if they want to amend their bylaws to permit this. But from my understanding of all accounts, that this that the applicant was aware of this through the CCRs, that you could not have them, and most of the neighbors living there know that they're not allowed. In addition to this applicant was made aware because she's rented her property before, and I think all the other letters stand in place. I spoke the last time reading some letters that were shared, and one of the things I did was meet with Ms. Fairbairn. She said that some of it was not true. I have not received anything from the person saying that, disputing what they've written the first time. But in their covenants, it basically says that any short-term rentals operating will be in a violation of their homeowners association, and they plan to pursue this in the event that she chooses to move further. What I've advised her to do, and all of my constituents in the area, is to meet with their other community members, talk with them, and see if they want to amend their bylaws so that they can operate them within the community legally. She seems to think that there are some other people that would be interested in doing this, and I think it's worthy of her going before the board, talking to neighbors and amending it. The board members submitted a letter. I have two. Both of them happen to be attorneys, matter of fact, which is interesting. But both of those submitted ones. And so, again, like I said, I can't support it because the neighbors don't support it. It's against the restrictive covenants. And the advice that I've shared with her is to take some time over the next couple of months, meet with her neighbors, get enough of them to petition to say that they support it and amend her bylaws so that if she wants to operate a short-term rental, that she can do it legally, and it does not create any ill will between the people in the community. So I ask that you support the denial, and I will submit these items for review.
Thank you, Councilor Dowell. We obviously don't have anything to do with what the HOA rules are. We have everything to do with the Metro rules are, and the Metro rules say if you operate a short-term rental, you have to be licensed. So that's what the case is really in front of us today for. So you're asking us to uphold the zoning administrator's denial? I
am, and going back to the Metro rule is, I think it is whether or not the person is knowledgeable about operating a rental and doing it legally. And so I go back to, I do believe that there was knowledge and understanding that this is not legal because the people in the community know that you can't operate them without a license within their community. Those two things are known. And so I think that that she was aware that she could not, and she chose the latter. It just so happened it was discovered that she could not, and she's going through the process. And so, I don't want to have a personal dispute with somebody. What she said she didn't know, the neighbor said all of them are aware of what the rules are. It's been discussed at their HOA meetings, and they've had conversations about whether or not if they want to amend their bylaws, because this is what the bylaws state. So we've been having this conversation about short-term rentals now for many years. So most people are aware that you have restrictions and licenses on them. So the point I'm making is she was aware, she operated it anyway. And that I ask you to support your original decision to deny. And what my recommendation is to my constituent is for her to go about this process the right way. I don't have an opinion one way or the other. It's with the neighbors. And I don't personally think they have an opinion other than they want to do things legally. And so they want any one of their neighbors who want to operate this, come to the HOA meeting, amend the bylaws so that they don't get any type of litigation for operating one outside of their restrictive covenants. So thank you.
Thank you. Any questions for the council lady? Thank you. John Michael.
Mr. Chairman, we're also joined today by Councilmember Scott Davis from Council District Number 5. Councilman Davis, do you wish to address the board at this point?
Thank you, board members, for volunteering your time. Thank you, code staff, for working hard and working overtime and long hours without additional pay. We really appreciate it, and we acknowledge that. I'm here for 3 items. The first one is not in my district, and I will defer the final decision of this matter to the district council member. I'm here for the first case, 228, which is Dean Design Group. The applicant, the people in my community, which is right behind this build, are in support. The applicant did a design which is half in my district and half in Mr. Withers' district, amplified on Main. He did a great job. He had community meetings, and he does a good building product. And Mr. Leibowitz is in the past has been a very good neighbor, here to both sides of East Nashville, and I am here in support. But I do want you to have the final decision rest on the shoulders of the district council member, Mr. Withers. And the next item that we're going to is case number 280. It is on 2408 Dickerson Pike. This is just a little bit past Trinity Lane. It's the old Hilltop Salvage. They're building a warehouse, and they're going to store some of the materials that may not look as nice, that are outside, and wanting to put it inside. And they've activated a sidewalk variance. For the sake of cleaning this site up, it has new ownership and making it look a lot better. It'll be getting rid of a large eyesore. And so I'm for them getting the sidewalk variance waived just to put up the warehouse to store their car parts, so that it doesn't look like I'll just say it. It looks better when it's inside a warehouse than outside, in the open. And it helps clean up the street a lot. So I would really appreciate the support for this variance, which I think it's on consent. And last but not least, case number 310, 236 Zophie Street. I'm okay with the setbacks. I figure with the setback variances, reduced or waived, it'll allow the builder to build a better looking house, for the area. Also, the builder has always, when they've had zoning issues or needing zoning, they've come before my neighborhood association, and they were able to answer questions. And they also adjusted a bill that they did on Meridian from a base zoning to a SP just to accommodate the concerns of the neighbors. So I have no issue with supporting the builder here for case number 310. And board members, I thank you for your time and have a great afternoon.
Any questions for the councilman? Nope. That means from us. Okay. John Michael.
Mr. Chairman, we're also joined by Councilmember Steve Glover. Councilman Glover, do you wish to address the board?
Thank you. Thank you. Once again, I've seen you guys more frequently over the last year than I saw you for the entire term I had in my first term. And I think this is one of the problems. And when we do things on the council, we pass certain bills without really understanding the unintended consequences. STRPs, we all are dealing with that, as you've heard already today. Sidewalks is another one we're dealing with. And so I specifically am asking you to grant the variance on 2017-160 on the sidewalk component of the variance piece. And Mr. Chair, if you would, I would like to just ask your legal counsel, if I may, where we stand with regards to the actual building and the process that will have to be followed if the variance is granted for this. If you would indulge me for that, sir, I would appreciate that.
Okay.
So,
Or is John Michael
well, I think, to John.
Here to help, Councilman.
Yeah, so if I may, I think we've had numerous conversations. I've had numerous conversations with you and Mr. Herbert with regards to the state and federal law on this, as far as the issuing of the building. Is that correct?
The short version is yes, that's correct. Federal and state law govern the primary question here that's at issue on our special exception before the board, which is this land eligible to be used by a religious institution for their structure? And of course the answer is yes. The fact that it happens to be regulated in part by the Metro Zoning Code is arguably a bit of a pro forma kind of a process, but nevertheless, state and federal law govern most of that.
Okay, so I've tried to be diligent, Commissioners, in making sure I understand exactly what the opportunity, what blocks, what non-blocks, et cetera, we could possibly do in Metro. So that part is nothing that I'm really speaking of. I literally want to just zero in on just the sidewalk element of this. And the reason I'm asking for the variance, it doesn't make any sense. This is on Earhart Road. You may or may not be familiar with it, but it literally, there would be 100-something feet of sidewalk here that does not connect to anything, nor would it probably ever connect to anything in my district. And so,
For the people that don't know, tell them where your district is.
okay, so I'm in Hermitage. This is literally probably as the crow flies. It might be 200 yards, 300, 400 yards, 500 yards from Wilson County. So I'm out in literally the general service district. So that being said, I have filed a bill that was supposed to be heard by the Planning Commission last week, and unfortunately I had a conflict, so I could not be there in order to be and speak on behalf. But I have filed a bill for nonprofits, religious organizations like this, to get a variance on the sidewalk piece. And the staff has approved that. They're recommending approval. So I'll go through the process.
That has to be voted on by the Metro
That's
Council.
correct. It has to be voted on, first of all, by the Planning Commission. Once it moves from there, then it will come to the council and would have to be voted on. But I have filed that legislation, and I am in the process of moving it forward.
So, I mean, that's just kind of cutting to the chase of this case. This is a church, and so
Yes, sir.
You're feeling that why should they not have to be compliant with the sidewalk bill that the council recently passed?
The bill that's right. The bill that recently passed.
Why do you care so much about this, and why are you speaking out?
It simply doesn't make sense. If in our districts, for each council person that is there, you kind of look at a consistency basis. You kind of try to understand what's what. This sidewalk would literally be on a part of Earhart that will never connect to, well, it may generations and generations down the road, but the sidewalk would probably be obsolete at that point. It doesn't make any sense to be here because it would be the only sidewalk that's there on Earhart other than that are in subdivisions, and no subdivision connects to this particular piece of property. So that's why I'm asking. I don't think that there necessarily needs to be a cost spent here when it will have no benefit to the community.
The planning department recommended the applicant pay the in lieu fee. What is your feeling about
I'm
that?
asking you to pass, or to do not ask them to pay the in lieu, and that's one reason I have the bill filed for the, and I don't remember the bill or the legislation number exactly, but I have the bill filed, and the Planning Commission, their staff, excuse me, the Planning Commission staff has recommended approval of the bill that I filed.
And it covers all nonprofits or simply religious institutions?
It may only cover religious institutions because I got kind of specific with regards to this. I'd have to go back. I don't want to tell you something incorrect. I know it covers the religious. I'm not certain it does on all nonprofits.
Any other questions? Okay. Councilman Glover, thank you.
Thank you, Chair, and I appreciate y'all's work.
John Michael.
Mr. Chairman, we're also joined by Councilmember Brett Withers from District 6. Councilman Withers, you wish to address the board?
Councilman Withers, welcome to the BZA again. I think you've been to probably all of our meetings in probably last 6 months, year.
I'm a frequent flyer, yes, sir.
Yes.
I am here to speak on two items. One of them has come before the board previously. It is case 2017-228 for property located at 809 Main Street. The Planning Department looks very closely at our urban centers such as Main Street, which is a Tier 1 center in the Nashville Next program, where we want to have density, we want to have development that activates the street and that has a lot of walkability. And the Planning Department staff asked or suggested that the applicant look at reducing basically a curb cut or a driveway cut from Main Street, because that would be disruptive to the pedestrian frontage there. And this case was brought forward because of that desire to have more of a solid retail or business streetscape along Main Street, rather than having more conflict between drivers and pedestrians, of which there are many right at that spot with a bus stop right there. So that is the genesis of this request that the applicant is bringing forward. I'm aware that he came before the board. Last time I had a letter of support. Councilman Scott Davis and I had a joint community meeting there on Main Street, had presented this case, and the community was in support at that time. I appreciate the board wanting to ensure that we're not building buildings that don't meet all of our standards. So I appreciate the rigor that you have brought to this case. It's my understanding that the applicant has gotten a little bit more information to present to you about what the estimated parking requirements would actually be for a hotel in particular, and especially for a hotel at this kind of a location where use of transit is highly anticipated, use of ride shares is already frequent, and frankly where folks could walk to most of their destinations and wouldn't necessarily need a car while they're in town. So I think there's a strong case for why a parking reduction for a hotel makes sense, in particular here on Main Street, and I appreciate him getting that additional information for you. There is a letter of support from the planning staff as well as from the MDHA Design Review Committee for the East Bank Redevelopment District, and just again want to reiterate my support for this request. It is convenient and a good thing that the property owner owns a couple of other properties nearby. If there happen to be overflow parking for a specific event or as a pattern, there is lots of parking adjacent to and across the street from this property that the property owner could make available. So I think that's a really good stopgap measure for the community concern, if there is one, about parking. So I would encourage you to support that today. And I welcome any questions you have about that.
I do. I have a couple. I don't know if they're for you or for zoning staff. Is there any movement or in maybe changing the zoning regulations to allow less parking for hotels? I don't know who that's a question for.
I'm not aware if that has quite made its way to the council quite yet. Some of the council members, and I'm one of those that have been really focused on sidewalk issues and some of those issues at the moment, but as a council and working with the Public Works Department and even with the mayor's office, we're really looking at making Nashville more pedestrian friendly, and sometimes that means having sidewalks or sidewalk requirements even if they're not popular, and sometimes that also also means encouraging people to get around other than in a personal vehicle. So that's something that the council could definitely bring forward at some point in time, but right now I'm not aware that we've made any progress toward reducing parking restrictions categorically.
And I'm asking because I think we have another case today that deals with parking reductions for hotels, and I believe the Planning Commission heard a case about a hotel and parking, and so it just seems like this is going to start to come up a lot, and I was just wondering if there's if we're going to start seeing these cases, maybe it should be handled legislatively than coming before us. I'm just having a conversation, I guess.
I mean, that obviously would be the preferable thing. I mean, do you have any kind of voice on these hotels? You know, obviously it's a great location for a hotel.
Correct.
There's not that kind of hotel anywhere nearby. If there are more cars than parking spaces, you as the council person, what do you think you would do to kind of work with the developer and the community to solve that problem if we were to give some sort of variance on parking?
Well, again, for this one in particular, I think there's a strong case for just even current practice about how people are getting to and from that area. That already is evident, and as I mentioned previously, the same property owner owns a property adjacent to and across the street from it that also has parking. So in this particular case, I feel that there's a lot of comfort that we can give the community that if there are more cars than there are parking spaces in that specific building, that there are places within eyesight where those people could park.
This board used to oversee curb cuts. We don't anymore, but we have this letter from Joe Kane of MDHA talking about how they're fine with that as long as you work on the proper location on Main Street. It seems like, I mean, construction has already started, right?
That's correct, and it's my understanding that this request is actually for a potential retrofit of the building. So it currently is designed with a curb cut in the parking garage, but the request is to allow a potential retrofit of some of that space to actually fill it in, perhaps as additional retail space at a future time. And, you know, for some of the more advanced cities, they're already encouraging folks who do build parking garages to build them with flat floors and to have them ready to be retrofitted for other uses if we do have less cars in the future than we do today. So I think that's a really smart way of going about it. For the time being, the use would be, the curb cut would be there, but if it makes sense in the future, this allows the applicant to go ahead and fill that in and maybe provide some additional business space there.
So we still have the letter in opposition from Ann Howe Billings Harwell, I think was one of the, owns a 714 Main Street and 734 Main Street. But have you heard from anybody else over there about this case and the parking issues?
I haven't. You know, again, parking is a frequent matter of discussion in East Nashville. We have businesses opening up along Woodland Street, for example, and sometimes the employees or even patrons filter over into the neighborhood streets there in Edgefield, and Edgefield neighbors are particular about who parks there, and I don't even park there myself. I just walk down there. But in this particular location, again, it's on Main Street. There is plenty of transit currently, and walkability, and the same owner does own sites nearby. So again, I'm really comfortable that concern can be addressed with immediately adjacent properties.
Okay. Any other questions? Okay, you had a couple of cases, another case that you went for.
The other case that I have today is case 2017-302 for property located at 821 Shelby Avenue, and the property owner, Ms. Terry Richardson, is here today. She's been a great neighbor for several years at that property, and has provided a really valuable service to our community by providing support to folks who need help in that building, and is looking to continue to do that and maybe expand on some of the types of offerings that are provided there. But that is something that personally I'm really committed to in our community. Is we want to have folks of all abilities be able to live in our community and be part of our community, and especially to be able to age in place. In East Nashville, we don't have a lot of housing that supports that. We have lots of houses that have staircases and tall and skinnies and things of that nature over in East Nashville. But, you know, it's really important that a community holistically represent everyone in the community, and everyone has a place there. And I think this property has filled part of that role for a long time, and Ms. Richardson has done a great job at that, has a good relationship with the neighbors there in Edgefield, and there's a lot of comfort with this request in that community as well.
Any other questions? Is that it?
That's it for me.
Thank you.
Thank you so much.
Councilman, I do have a question for you. I think we're going to, at some point in this meeting, revisit the 8th Avenue case. I forgot.
96 North 8th. Mhm.
And I was wondering, since you weren't here for the bulk of the argument last time, if you had anything to add or...
Sure. I mean, really what it comes down to for me is that a lot of the concerns about, a lot of the discussion, I guess, within short-term rentals is to say, you know, most from what you hear from the owners is that most of them are fine and that we need to take corrective action for the quote-unquote bad actors and just enforce the rules. And the rules perhaps are unclear, but I think there are some cases, and this is one of those, in which the community concern is visually evident. You can understand why a certain behavior that is can be captured visually is not something that neighbors feel benefits their community. They feel that it's disruptive, whatever the details of it are. And if we have a 3 strikes and you're out rule, it's my opinion that this should count as one. I'm not saying revoke the permit, but I'm just saying these are some of the types of behaviors that are concerning in the community, and that it is appropriate to apply a strike to it, and that helps to set a record. If that type of behavior continues at that property, then we would, you know, be back here before you possibly looking at revoking a permit. But the discussion from neighbors is that, you know, a lot of times they are reluctant to call into codes or call the police, although they call me. But they're reluctant to do that for a number of reasons. And one is sometimes fear of retaliation from owners, or number 2, just the fear that nothing will happen from it anyway, and that they're sort of wasting their time. And I think that the discussion in this board that took place at the original hearing potentially leads to supporting the argument that there is no purpose in complaining because nothing will happen. I mean, just frankly. And so to the extent that the community believes that regardless of what behavior people do, if they're a short-term rental owner, they can do any number of things, there are no repercussions for that. That supports the argument for neighbors of why we should cease issuing those permits entirely, because there is no enforcement of quality of life concerns. So just within that context, this particular one I think is a great case study for the application of strikes or not, and what enforcement relief neighbors can get from Metro government or board or the court. And just again, I mean, if y'all find that applying a strike is appropriate, which I believe it is, then that supports the idea that there is potential enforcement and repercussion. If behaviors continue, we can revoke a permit. If you find that that is not a strike, that supports an argument that there is no enforcement available, and that Metro government should continue to look at whether or not we issue these permits.
Because you mentioned it, I think it's a relatively new thing, but there is a way to complain anonymously.
Mm-hmm.
I don't know if Mr. Osborne wants to just quickly tell us how to do that again, if you wouldn't mind.
In case it
John?
saves Mr. Osborne a trip, I will note that the code's complaint process to property standards is and has always been an anonymous process, whether through the website, through a phone call, or whatever else. You don't have to leave your name and number if you have whatever concerns about repercussions or anything along those lines. Additionally, the new reportage system that has been put in place also allows an anonymous complaint system whereby short-term rental property concerns in particular can be routed directly to the right people in property standards, like Mr. Osborne and some of his colleagues, to, in a timely manner, take up those issues in an expedient way and try to continue the good work they've done, as they have on very literally hundreds of other incidents, to prosecute, put out the notices of violation, and work towards court proceedings.
So maybe spread the word that it can be an anonymous process.
We do. I appreciate you raising that point and reminding everyone of that. You know, again, it goes back to sort of the letter that I read to y'all from, not that specific case, but from a similar property where this type of behavior has happened repeatedly, even with the owner living about 2 blocks away, and even with the neighbors actually having that person's phone number, these behaviors still continue at that particular property. And I read a letter from neighbors explaining what their experience is like. And one of the things that they mention in that letter, which I read to you, is that they at no point had reported that to a metro body, partly because they didn't think anything would actually happen because of it. And that again, that really is the discussion: is what behavior is so egregious that it counts as a strike. And I'm not sure that we have actually, apparently, we have not reached that point yet, and that is concerning to me as a community advocate. Councilmember Allen was of the opinion when she passed the original enabling legislation that some of the quality of life concerns could be reported as strikes, and that was sort of given as a little bit of a guarantee to the community that if disruptive, rowdy behavior takes place at these properties, that there is a mechanism in place to ultimately, if the behavior continues, there's a mechanism in place to revoke that permit. And Councilmember Allen was quite surprised by the discussion that the board had last time on this case, as was the ad hoc short-term rental committee when we were all there. So I think a lot of people on the council who have different opinions on short-term rentals generally believe that this is an egregious case, that neighbors would not want that next door to them, that it would be a community concern, and that it ought to be addressed in some form or fashion. If there are revisions to the Metro Code that are needed to clarify what that language is, then we certainly welcome that input. But this is a really important discussion, because a lot of the quality of life concerns are people are loud, or they're cursing, or they're drunk and disorderly, or things like that. Technically, a police officer could report on that if the police officer were able to get there in time to observe it him or herself, which is frequently not an issue. But some of these cases are so just visually evident that you can, people frequently send me pictures of them and say, what are you doing about it, Councilmember Withers? And in this particular case, I said, well, I'm going to report them to codes and see what happens. And so here we are.
Anything else? Thank you, Councilman Withers.
Thank you.
John Michael.
Mr. Chairman, as you know, we always operate with a consent agenda here at the Board of Zoning Appeals. Our consent agenda operates such that one board member reviews each of the cases on today's docket and determines in advance of the hearing any such cases where the appellants have met the criteria for their requested action. If the reviewing board member determines that testimony in the case would not alter the material facts, in that case, is recommended to the board for approval. We'll enter into the record those cases that have been recommended out of today's docket, and if anyone is here in opposition to any of those cases, just raise your hand, make sure that I see you. We'll wait till we announce the consent agenda before you raise your hand, just to be abundantly clear. If one of the cases that I identify for the consent agenda is one that you have opposition to, just make sure I see you. We'll pull it off the consent agenda and hear it in its regular order. No problem at all. There are 4 cases identified for the consent agenda, the first of which is 2017-246. This involves the property at 300 Stewart's Ferry Pike. The request is for a variance from sidewalk requirements, Mr. Chairman, and the condition on this recommendation for the consent agenda was that the alternate sidewalk plan that was submitted by the appellant and agreed upon by Public Works, Stormwater, and Planning is, in fact, the plan that is utilized as part of the condition for the consent agenda placement. Is anyone here in opposition to case number 246? The second case recommended for consent agenda is 2017-280, involving the property at 2408 Dickerson Pike. Councilmember Davis spoke to you about this property where the request is for a variance from sidewalk requirements at a location where a property was damaged by fire, and now a new warehouse is being constructed. Is there anyone here in opposition to case number 280? Seeing none, the next case identified is case 2017-305. For the property located at 5326 Anchorage Drive in the Creve Hall neighborhood, the request is for a variance from height restrictions for a detached garage to the rear of the property. Is there anyone here in opposition to case number 305? Seeing none, the fourth and final case identified for the proposed consent agenda is 2017-316, involving the property at 7178 Harper Road in Council District Number 1. The request is for a variance from the side setback requirements for the construction of a detached carport. Is there anyone here in opposition to case number 316? Seeing none, each of the 4 cases recommended for the consent agenda will stand. Those are cases 246, 280, 305, and 316. Only those cases are on for the consent agenda at this time. Do you have a question, sir?
If I may.
Sure.
The appeal case 2017-280,
Do you wish for that to be heard in its regular order, sir?
say it again?
Do you wish for that case to be heard in its regular order? Do you oppose that variance request? Very well. The consent agenda proposed is case 246, 305, and 316, and only those 3 cases.
Okay. That is the proposed consent agenda. It's been properly moved. Is there a second?
Second.
Motion's been made and properly seconded. Any discussion about the consent agenda? Seeing none, all those in favor signify by saying aye. Aye. Opposed? Passes unanimously.
With that, those 3 cases, 246, 305, and 316, have been approved by the Board of Zoning Appeals. If you are the appellant or interested party on those cases, you're free to leave. You're also free to stay if you wish. The remainder of the cases will be heard in their regular order as identified on the docket. Mr. Chairman, 2 other items that we wish to take up here at the outset before getting into the regularly called docket. First, as has been previously noted in the discussion with Councilmember Withers, the previously heard case for a short-term rental property located at 96 8th Street in East Nashville is still an open case as there were not 4 affirmative votes identified. 2 of our board members were absent at that last meeting. When the second of those 2 arrives, we'll take up that item to see if the parties have in fact reviewed the case file and are prepared to vote today. The second item to identify is that the code staff, namely the Property Standards Division, has identified 2 cases that are already involved in legal proceedings now in the environmental court and simply awaiting ruling from the court. Specifically, case 2017-303 involving the property at 11 Music Square East, unit number 403, and case 2017-307 involving the property at 1536 Arthur Avenue in Council District 19. Both item A appeals involving short-term rental properties are cases that are already in front of the environmental court and merely awaiting ruling from the judge. Staff has asked that we suggest to the board that with those rulings pending, that they would be appropriate for deferral to a later date. With a regular BZA case, we would just do that administratively, but because it is the appellant's case here, not the government's case, we wanted to bring it to the board with the request to defer those to a later date.
Okay. Is there a motion to defer those 2 cases?
I'll move to defer cases to 2017-303 and 2017-307 to a date that's after the...
It's just 1 meeting or 2? Do you want to?
Just a moment for staff to confirm the upcoming court dates. Mr. Chairman, that would be 2 meetings, which puts us to our first BZA meeting in December.
Okay.
Okay, I'll continue with defer to 2 meetings.
Okay. Motion's been made to defer these 2 cases to the first meeting in December. Is there a second? Motion's been made and properly seconded. Any discussion? Seeing none, all those in favor signify by saying aye. Aye. Opposed? Passes and gets deferred 2 meetings. John Michael.
So for those who are here on cases 303 or 307, those have been deferred to the first meeting in December while court proceedings continue. And with that, Mr. Chairman, we'll move to our first regularly docketed case. The first case on today's docket to be heard is 2017-117, a case that has been before the board for quite some time but not heard, as the original filing of the case had to be backed up a little ways, and then the sidewalk ordinance took effect on July 1, thus requiring a sidewalk variance in addition to the special exception that otherwise would have been an issue. The property in question is shown here on the zoning map, 2618 Buchanan Street. The request is for the aforementioned special exception and then variances from sidewalk, landscaping, access perimeter landscaping, and parking surface requirements in an RS5 zoning district for church use and modular structure for daycare use. The aerial shows the property here in something relatively close to its current configuration. The site plan submitted gives an idea for the layout of the property as proposed with the parking as discussed and the modular building to the rear. This is a dated shot from the assessor's office, but nevertheless, the primary structure on the subject property. And from my recent site visit, the view up and down the street there on Buchanan with Ed Temple to the west, back inbound to the east, and gives you an idea of the absence of sidewalks presently. Because there are opponents here on this case, the appellant will have 15 minutes to come forward and make the desired presentation. Should do so at this time. Identify yourself by name and address and make the desired presentation on the appeal for case number 117.
So will the applicant come forward, please?
I believe that's Mr. Kevin Kane is the appellant and Jim Attar is the owner of the property.
Yes, good afternoon.
Can you press the button?
I'm sorry. Yes, sir.
There we go.
Good afternoon. Yes, I'm Kevin Kane. I'm the appellant.
What's your address?
2618 Buchanan Street.
Very good.
A couple of things that were noted. I'm not really sure how to present with this. I've never done this before, so hopefully we'll get through this. I did submit a more current layout of what we were proposing at some time ago. Be about 7, 8 copies were left.
We should have that in our packet. Looks like this.
No, sir. No, that's not what was left.
You've got a bunch of pages.
Is the date August 1st, 2017 in the title block?
Pardon again?
Is the date in the title block August 1st, 2017?
This is what was submitted, yes.
We have it in the back. Proceed.
Yes, a couple of things. I think we received a phone call regarding this case. The case is stating that we're asking for a variance for sidewalks, fences, and landscaping, and those we have come to a conclusion not to ask for a variance, but for a deferment on putting those things in.
What do you mean by that?
Well,
Defer to like a meeting a month from now?
No. I don't know the proper term, but let me just explain what was explained to me by the gentleman that provided, the architect that did these plans for me, who said that we should ask for deferred from doing it right now or immediately after we set the buildings up. Not that we're not going to do it, but ask for a more extended time to put those items in.
John Michael, can you help us out here? They're asking to do these things, but do them at a future date, which is unknown. The shaking of John Michael's head, it seems to me that under our building code, if you're going to build these buildings, you either have to build those things now or get a variance from us. Those are your only two options.
Okay. Could I ask for you to explain exactly? I mean, I understand what a variance is. Is a variance not doing it at all?
Yes.
Okay, and that's not what we're asking for.
So why wouldn't you do it when you're building this? Why wouldn't you build a sidewalk?
It was our understanding, after having conversations, let's first of all be mindful we're not used to doing these type of things. Mm-hmm. Second of all, we want to comply with the law. I think our first response, it comes to finances, okay, what it would cost to put these things in. And when you're not borrowing money to do this, it can, we're actually raising these funds among our congregants to do this work without us using what little borrowing power we have for future projects that we have.
So are you talking a month from now, 6 months from now, a year from now that you think you'd be able to do these things?
I'm going to be honest with you. I'm not even sure how much time we're going to be given to do anything. I'm not understanding most of this. I've been down here several times to talk with people. Information is very vague. I've tried to do the best I could to make sure that we were in compliance with what was been asked.
I know we just started, so this is kind of where I am on this. It doesn't seem like you all are financially ready to build the other things. You just said so. But if you do not get the variance, then you have to build it anyway. So the question is, are you ready to be in front of this board to even ask for this or to proceed with this? Because what you're asking, so the variances were special exception, sidewalk, landscaping, and parking. Did you all have a community meeting?
June 29th.
Okay, and who showed up for that?
No one showed up for that meeting.
But you sent out the letters and all that?
Yes, sir, we did, according to what was sent to us.
So what are you asking for us today if you're wanting to put off the sidewalk, the landscaping, and?
All right, it's our understanding, let me say, instead of our, let me say me, because I'm the one doing all the legwork, that number one, we needed a permit to even put the buildings up.
That's true. Yes.
Okay, all right. So we understand that, we
Yes.
got that.
Yep.
We were not aware that sidewalks, fencing, and
Yep, and then landscaping because of the type of building, I think.
right, would play a part into that.
Yes.
And we are currently seeking the pricing for those things. They may or may not be extremely costly. I know if you could see some of the concrete work that's already been laid, that did cost a little bit. But we're not opposed to. We've had parking lot people out there. We understand what that's going to cost, and we're not saying that we need a long time to do. I guess what we need to understand is how much time are we given from the time this is granted to get all this done, and that's what we don't know. We have no idea.
Mr. Chairman, if I may, on behalf of staff, assuming the granting of a variance of any sort or any action from the Board of Zoning Appeals, there are 2 years to obtain the required permit. So once a board grants whatever, you've got 2 years to get the permit in hand, or you're all the way back to square one.
Okay.
So do you understand? So if
Yes, sir.
you grant what you give today.
Yes, sir.
You've got 2 years to start, and that's valid for 2 years. And
Okay.
then after 2 years, you got to come back here again.
Then that's perfect. That's good enough time to get all that done.
But regardless of what happens, I mean, if you install, if you start if you take that permit and start the construction, you'll have to do whatever is ordered
Sidewalks, landscaping.
before you can actually use the building.
We understand that.
Okay.
Yes, sir.
Are there sidewalks there now? I can't really tell from.
There are no sidewalks
Okay.
on that side of the street of Buchanan from
Oh, I see.
D.B. Todd to John H. Merritt. They're all on the opposite side of the street.
Sorry, I missed the introduction.
Can you walk us through your variance requests? We have them written here on the permit application, but it would be helpful if you walked us through it.
Well, the variance request was for sidewalks.
And basically, she's saying why? Why do you need a variance request for these things?
Well, all right. At this point, we're not asking for a variance, and I think you've already answered how much time we have to put these things in. So really, we're not asking for a variance for sidewalks, fences, and landscaping. We're going to do those things.
Well,
Mr. Chairman, forgive me, I need to interject because I'm worried that there's a misunderstanding here. If the board grants a variance from sidewalks and everything else that's sought here, and then the appellant obtains a building permit, that can happen anytime within 2 years of BZA's approval of a variance. Obviously, the appellant would have to obtain the variance first from the BZA in order to get out of sidewalks, or if the variance is not granted, would have to then submit a site plan that shows the sidewalks in order to get the building permit. This is not a matter of as long as we build the sidewalks within 2 years of a board approval. This is either a variance or not a variance, and regardless of what the board does, it's if they get a building permit within 2 years of board action, then that's what keeps them in the clear in terms of whatever gets approved or here today.
Okay.
Well, what I'm reading on the permit application is that there's a variance request, there's a buffer B required, a landscape buffer, which is 10 or 5 feet with 6-foot solid fence. Your request is a 5-foot buffer without the solid fence. So are you not going to build a fence at all, and why wouldn't you build the fence?
We are going to build a fence per code.
you're going to build a 6-foot solid fence with the 5-foot landscape buffer. So if you do that, it doesn't sound like a variance is needed.
That's what I've been saying.
Okay, it's just not clear because you haven't walked us through
Well,
it.
because first thing is when I came back down to codes administration and we discussed us changing our mind and going and not asking for the variance, I was told that we take that up at the meeting. Just state when you come to the meeting that you're no longer seeking a variance for those items, and it should move on from that. Because I did come back down here to perhaps make it clear so there was no misunderstanding when I got before you all.
So are we only here to hear the special exception? So it's the sidewalk? Isn't there a special exception to use this as a church, or is that
Let's
not?
do these one at a time. Mr. King, do we understand, obviously you need the special exception in order to have a religious institution operated residentially zoned property, so that's fine. No variance sought with regard to the buffer and the fence and the landscape requirement, correct?
Or the sidewalk.
You do need a sidewalk or not a sidewalk variance?
We're going to put the sidewalk in.
Okay.
It's our understanding that there are future plans coming down Buchanan, the sidewalks are going to be required. That's our understanding.
Do we understand that you do not seek a variance with regard to having 2 entrances or access points on the property and will build it with only 1? Is that correct?
That is correct.
Okay. Do we understand that you no longer seek a variance with regard to the hard surface and dustless material requirement for the parking area, and you're no longer requesting a variance that would allow you to use gravel?
That is correct.
Okay. Finally, do we understand you're no longer seeking a variance from the 5-foot front lot line perimeter landscaping requirement?
That's correct.
Okay. All that's before you is a special exception, members of the board.
Thank you for clarifying.
Okay, continue. Special exception, okay.
Because the submitted site plan, it apparently meets. Has staff seen the new site plan? I mean,
It's in our package.
if it's in our package, you've seen it. So the appellant is obviously under the impression that the site plan, it meets
Sure.
everything except for, we said the special exception.
There's some people here in opposition. I think this would be a good time to hear from them, and then you can come back and you'll have almost 10 minutes to kind of respond to that, okay?
Yes, sir. Yes, sir.
Okay, so we're going to hear from the opposition, and you could come back up after that.
Yes, sir. Thank you.
Thank you. Let's hear from the opposition, please. Anyone in opposition in this case, please come forward, identify yourself for the record, your name and your address, and why you're in opposition.
I'm
Press the
Carlin
button.
Harris.
Okay.
Carlin Harris, and I have the property behind that property. And I have several concerns. When I first saw the trailers on the lot, I thought, well, perhaps someone dropped those off and they'll eventually move those to another location. But I later found out that those were planned, put there with plans to make it into daycare. North Nashville is experiencing a renewal, an upgrade, urban renewal. I don't see that in that property. That seems to be a downgrade to have 2 modular trailers like that. There's nowhere else on that street or area that has anything like that. That really, quite frankly, is an eyesore. I'm familiar with that property. That's one concern I have. Another, with a daycare there, where will the playground area be? I'm concerned about children being unsupervised, throwing over the fence, damaging property on my lot. That's a concern I have. Another is this a temporary thing to where if this venture does not succeed and they're later gone, what now? What becomes of the 2 trailers and the other things that are being proposed.
If we give the grant the special exception for the trailers, it would be for this applicant only. So I think what you're asking is, let's say if it just goes away or sells it to someone else and the trailers are still on the site, what happens? Well, the new owner couldn't use the trailers on the site, and so codes would, I guess, eventually have to tell them they are not allowed to have them on the site because that only applied to this applicant.
I see that being a possibility. There have been a number of businesses in that location, and of course, is this a proposed daycare and so forth with support, or are they hoping to build a building up? Daycares are good, they're in need, but there's a possibility this may not succeed. What then? As I look at the layout of the lot and the flow of traffic, one way in, one way out, is that feasible? The distance from my property in the back, that's another concern. Has this been surveyed? I've got a number of concerns.
So your main strongest objection is the modular trailers, but then also this use as a daycare.
That was one of the first things that concerned me. To upgrade the area, this seems to be a convenient way of setting up a daycare or whatever is proposed, but is it feasible? It's definitely not attractive. It would be a downgrade to the area as far as I can see. Is there a different approach they could make to build something that would be attractive?
Like a permanent structure, not this, is what you're saying?
Yes.
I have a question regarding the daycare. Is there going to be a daycare in this building? It's not clear to me. The recommendation we have from the planning department doesn't address the building to be used as a daycare. It says it was formerly a daycare.
It used to be used as, so it sounds like the applicant said he were going to build a church there, I guess.
Yeah, can the applicant just clarify if there will be a daycare?
Yes.
Please.
Yes, thank you. No, there will be no daycare on this
What
property.
will happen in these two buildings?
Okay, these two buildings will be, if you look at one of the plans submitted, these two buildings will be 3 offices and an open space for fellowship for the church. And I don't know if I'm permitted to go any further than answer the question that was asked me.
That was the question, so.
All right, that's all right.
Thank you.
Other questions?
It comes back to the appearance to me. It's a convenient approach, but is it the best approach? It's a downgrade to the area. There's a lot of construction taking place in North Nashville, and the buildings that are being built and houses and so forth, they comply with codes regulations, and they are an upgrade. They're attractive. But I don't see that with these modular homes. That's a convenient approach from what I can see to what they're trying to do, but it's a downgrade to the area.
Any other questions? Do you have anything else to add?
No, that's it.
Okay, thank you. We're going to hear from the applicant again. Please come forward. Oh, you can keep that. Okay, this is the rebuttal time. You have a little over 9 minutes, so you heard what he said, that it wasn't in keeping with the neighborhood and the direction it's going. So how do you respond to that?
Yes, sir. How I respond is that it is going to be, I can understand his concern, number one. I can understand his concern, and I can understand that many of the neighbors might have concerns about the value of their properties. These are things that we have taken into account. Of course, the way the buildings look now is not the way the buildings are going to look once we have permission to proceed. There's going to be a great significant facelift on those buildings to enhance the community, not degrade it as a result to the fencing, the landscaping, the parking. All of that's going to beautify that entire property. And I'm sure that I didn't get his name. I think it was Mr. Harris, who's a neighbor. This building has been a numerous of things. And when we got the building, it was an eyesore, and we have significantly, cleaned it up as relates to moving dilapidated fences, piles of trash in the back. We've painted it solid colors versus multiple colors. We've did our best to keep it clean, and we do have plans on being around for quite some time because we have lease purchase agreements for this property. We're not going anywhere. We also have an agreement to purchase a lot next to it to expand our ministry as well. And the buildings that we're asking permission to put up are not there permanently. We're only going to use them temporarily until we can get to the place to where we can add on to the existing building or just build a brand new structure with approval with all the properties that we will own at that time. I'll
ask you again, what's temporary? Is it months? Is it years?
We're probably looking at 2 or 3 years, yes, sir. Which is what they're used for. They're going to be set up on cinder block foundation. The curb appeal is going to be nice. The fronts are going to be nice. With I think we're going to be using stove or some of that nature that's going to enhance it. It's not going to be an eyesore to the community, not one bit. Number one, it will be a disgrace to the community as well as the gentleman that has just rehabbed the house next door. Number two, it will be a disgrace to us because we're considered to be pretty classy people, and as a leader of that organization, I like nice things, and so we do have plans to make sure that those are not going to be an eyesore for that community whatsoever. And as far as, well, we already finished that. There'll be no daycare there, so there's no reason to talk about a playground with kids throwing things, over the fence or whatever. Right now, as the way you see it, we get a lot of traffic through there that has nothing to do with the church, and it aggravates me to no end. People park there, people turn their cars around in there, and we just can't wait till we can kind of stop some of that extra traffic that's unnecessary. Even kids run through there. Even the neighbors, his neighbors on either side of him, cut through the yard to come to Buchanan Street. So it would not be an eyesore, to answer his question.
Tell us about the religious institution. What is the name of it? How many members do you have? How frequently do you meet?
The name of the institution is Victorious Life Church. We're associated with the Church of God in Christ out of Memphis, Tennessee, one of the oldest African-American Pentecostal movements in the world. We currently are under 50 members. We meet twice a week. We meet on Sundays, and we meet on Tuesdays.
So if you're under 50 members, this is kind of an ambitious plan, because I imagine you could probably fit 50 members in the current building, right?
Correct.
So you're looking for the future?
Yes, sir, we are.
Okay. Any other questions?
Do you have any drawings or anything of what you're planning to do?
We are currently working on a elevation for the outside. Yes, sir.
You've hired an architect?
Yes, sir.
Okay, so did some of those pictures?
Same architect, the Larkin Group. Yes, sir.
Okay. Any other questions? John Michael, we have another person.
Yes, I believe there was one who wished to speak in opposition that we just missed previously, so apologies for that. If we could invite that gentleman forward, and if anyone else is here in opposition, please come forward at this time. Take one of the seats at the front table.
Please state your name, the address, and why you are here in opposition.
My name is Thomas Lipscomb, and I live at 2704 Jenkins Street, the street right behind this church. And I have a lot of concerns. First of all, I don't quite understand that he doesn't need all these exceptions. I mean, if you give him all the exceptions for the sidewalk and the parking and the fencing, can he start building? I don't trust this facelift. Lord knows I have nothing against churches, but like my partner said, or my neighbor said, that I don't believe that this is going to be no facelift. If we start off like this, when would it facelift? Our community is really priced me out, but it's really looks good. And if we can't put in sidewalks.
How long have you lived over there?
Since 1959.
Wow.
Huh?
I said, wow.
Yeah, long time. I like the neighborhood. It's
My
kind of gotten old.
my father used to have his medical office on Buchanan Street, Dr. Ewing. So
Yes.
I know the neighborhood well.
Yeah. I remember. That was a good while ago.
So why don't you like this use right now? You said it's not against churches, it's just the way he's designed it?
It's going to be too much traffic in the first place. There's 5 more churches right around in 2 or 3 blocks. All right, so that doesn't have anything to do with his, but there's going to be too much traffic all over the city. But then he's not going to have the sidewalks. He said he don't need to do them now.
Can I clarify that for you? Because I was also confused as well. And from what we heard from the testimony is that he will put in the sidewalks and he will do the landscaping and all the other things that were
And with all other things before he start building. I mean, not later. I mean, it all goes together, right? Okay. I still think that there's too much traffic, and I don't trust that this is going to be facelift. All indication is that we can't afford to facelift it, and it looked like it's going to be some homemade stuff there. That's where the sidewalks look now, and there's still gravel all around. There's no attempt to.
Well, if he builds the sidewalks, there's a special way and size and material and structures that he has to build for the Metro Code. You just can't do-it-yourself sidewalks here in Nashville. You've got to have people that.
But my understanding, we can't afford to do that yet. We need some time. We need 2-3 years to put the sidewalks in. We want to go ahead and get on with the church, and then we put the sidewalks in whenever somebody keep knocking on the door and make us.
So this is how it works. If he's going to use those portables as far as what he wants to use, all those other things get triggered, and he has to build sidewalks and all the things he's asking for if we don't give a variance.
Well, I'm against the bill on that because it doesn't go along with the rest of our community, and I've never been noticed. Now I've been down here more than once about this meeting, and some of my neighbors were too. It was several of us here the last time. I guess people just get tired of coming, but there hasn't been a community meeting that I know about. Nor Mr. Harris.
You weren't invited to a meeting?
No, I was not.
How far away do you live, do you think?
1 block.
John Michael, what's your address?
2704 Jenkins Street. That's Jenkins and Buchanan and Aspirin, and yeah. No, and nobody that I know has been notified for a meeting, because I went around and talked to a bunch of people before, and a lot of people don't even go that way. So
If you had gotten a letter in the mail, would you have come to a meeting?
Sure I would. We have several, all the buildings going on around there, people changing the zoning. I go to meetings all the time, but our neighbors were not notified. I would like to know who all was. None of my neighbors were.
Okay, thank you.
I just want to clarify for you that we were trying to explain the process, and unfortunately, we don't have the jurisdiction to put conditions on this that improve the look of the actual building. We can only rule on the sidewalks and the fence and all, but he is going to comply with code, he's told us. So we were just trying to clarify that for you.
Right, and even if this was to get approved, I would hope that you all would want to see something better than that picture right there, a better drawing than that, and he be held to it looking like that, but not as it is right now, because I suspect that when it gets finished, it's going to look like that.
Yeah, the codes inspectors will come out upon completion and during the construction to make sure that they are abiding by the law, by the code.
Okay, well, okay, I'm against it, and I think that the neighbors should have had a meeting to express their opinion. We never got that.
Yeah, thank you. Thank you.
Okay, we'll briefly have the applicant come back and respond to that, and then we'll have our deliberation. So please come forward. Okay, so once you, again, you're hearing about the aesthetics of this and what you're planning to do. And so how do you speak to the concerns of your nearby neighbors?
I'm sorry that the neighbors feel, or this particular neighbor feels, that we're not going to do any facelifting to these two buildings. First of all, these are not houses. These are considered to be modulars for business use. They're open space. And that's the first thing. Number two is that I'm sure they could confer that the property, before we obtained it in April of 2015, did not look like it does now. It was full of trash and debris and these one thing and another, and we did clean that up ASAP, immediately. It does, as you can see, the parking lot is of gravel. Of course, by us seeking the permit, we understand and know that we would have to do all the things that is required by codes to make sure that it is done. I think that it also needs to be noted for the neighbors that we're not going to be able to just put up the fellowship hall and the offices and proceed, that everything is going to have to be done before we're given clearance on this particular project. All I can say is that what we're desiring to do is enhance the community, not only with the property, but also our ministry, to make the community better, not worse. I'm 45. I was born and raised in North Nashville, 9th Avenue North to be exact. And there are yet a lot of dilapidated properties within that 600 square of Buchanan Street. As a matter of fact, I saw some behind. There are some on Jenkins. There's some on Aspen. There's some on Deerfield. There's some on a lot of those streets behind us. All those houses have not been brought up to codes as of yet, or even beautified. So to single us out is...
when you do major construction, that's when things get triggered.
Yes, sir. We understand that, and that's what we're going to do. As far as the letter, I have a copy of the letter right here. We did send it out. We did exactly what we was asked to do by Ms. Debbie Livesey. We made copies, brought stamped envelopes down here, and sent them out way back in June 14th. The letter is dated, and the meeting was held on the 29th. I know that because before I went on vacation. And no one showed up. We also had a conversation with our councilman, Mr. Ed Kendall. We made contact with him as well and spoke with him about what we wanted to do, and he asked a series of questions and thought that it would be, I wish he could have been here today, and thought it would have been a good asset by what we were proposing to do.
Okay.
While we're deliberating, can you please show your neighbors this site plan and explain to them that the two modulars are going to go behind the existing building?
Yes, the two modulars are going in the rear of the property.
But I don't think that helps their cause because they live on the back.
They live on the back.
Street, so I think that's
those modulars are going to be to the back of their homes.
Less desirable for them to be.
It might be less desirable, but they might appreciate you talking to them about it.
Okay.
Okay. Any other questions for the applicant? Okay, we're going to close the public hearing. Time to deliberate. So let's start off by discussing what we are voting on today. What are we voting on? Special exception. Okay, so to use this as a religious, John Michael, are you going to weigh in on this? So what's in front of us?
Religious institution, 17.16.170 out of the zoning code is the section that talks about it. You're making the determination as to whether or not it meets the conditions or if there's any...
For a religious institution, but we're also voting on these two modular buildings. Right? Those are the two things.
I don't really understand how that, I thought we just had to vote on, and if they meet the requirements for the special exception.
Oh, so it's just special exceptions for church? Because if, I know we had the Episcopal school over in East Nashville that had a modular, that we had to grant them permission to use the modular classrooms.
I believe that was about another structure on the property requiring a special exception. So the modulars in this scenario are no different. They require special exception approval as to be used for the religious
But this is just kind of
institution.
a blanket religious special exception. We're not necessarily voting just on modulars alone.
Right, and just because it's zoned residentially is the issue that requires a special exception approval.
Okay? Deliberation.
Well, I think they've established the grounds for the special exception by the testimony that we've heard, and I would hope that the applicant is going to continue to be a good neighbor and address those concerns, but I think the grounds for special exception have been met.
I agree with you.
Does anyone have a motion?
I'll make a motion that we approve the request for special exception as the grounds in evidence before us are established.
There's a motion been made. Is there a second?
I'll second.
Motion's been made and properly seconded. Any discussion? Seeing none. All those in favor of the motion signify by saying aye. Aye. Opposed? Passes unanimously. John Michael.
Mr. Chairman, the next case we're going to bring to the board is not the next docketed case, but instead revisiting the case that was heard at our last board meeting involving the property at 96 North 8th Street in East Nashville. I know you've already talked to Councilmember Withers about that today. One of our board members present today was not present at the last meeting. That was Ms. Chappell. So in order for her to have an opportunity to vote on that matter, we'd like to first go through the preliminary questions. 265, thanks. This, of course, is on case 2017-265, just for clarity in our record. Ms. Chappell, have you had the opportunity to review the entire case file for case 2017-265?
I have.
Have you also had the opportunity to review the video or audio to hear the full hearing proceedings?
Yes, I have.
Are you in a position to vote on a motion regarding that case today?
I am.
Mr. Chairman, the board has discretion here as to whether to take up the last motion filed anew or just create a new motion with regard to whether or not, and Ms. Legal Counsel may want to guide us from here, but one way or the other, we're ultimately seeking, hopefully, for affirmative votes on a motion to conclude case number 265. Counsel?
I think since the motion at the last meeting failed, there needs to be a new motion. Now, y'all can make the same motion, but I do think there needs to be a new motion.
Very good.
We're missing a board member that was present at the last meeting. How does that work?
Well, we vote what we have, and anyway, any member could change their, oh, can you all go ahead and...
If we could invite the other gentleman from the prior
Bobby.
case outside
Yes.
while the board continues.
So, under these cases, you're allowed to change your vote, so we could just have a new motion, new vote, and this is who we have today. So remind us, yes.
Mr. Taylor would be eligible to vote because he's heard the case.
Yes.
He could,
Well, this gets held open for 30 days, so.
Correct, and we have another board meeting that falls within that 30-day
If we don't have a
window.
resolution today, then it will be the gift that keeps on giving for next meeting, so.
May I ask, why can't we just keep the motion from last time and see what our board member, how our board?
Well,
Because the
I-
motion failed,
It
so you
failed.
have to have a new motion.
So, yeah,
that's
I mean,
what-
we're here, let's vote. Maybe people change their mind, maybe we have a, so remind us, so the motion that failed last time was to uphold the zoning administrator?
That's correct. I believe it was Ms. Carpenter who made the motion to uphold the zoning administrator's decision
Of a strike.
that the incident did in fact equate to a strike for
Okay.
purposes of STRP permitting analysis.
So we're either upholding the zoning administrator and saying he was right to say that this is a strike, or someone could have a motion to overturn and saying that wasn't appropriate for a strike. So let's hear some motions.
Okay, I'll move again that we uphold the zoning administrator and consider it a strike.
Okay, motion's been made. Is there a second?
I'll say.
Okay, motion's been made and properly seconded. Now we have a new person that's going to vote on this motion. So all those in favor of this motion signify by saying aye. Hands, please. And opposed. Okay, so 2, 4, 3 against. I think it's, well, let's call for a second motion. Is there another motion?
I'll move that we find that the zoning administrator erred in his determination.
Okay, motion's been made. Is there a second of that motion?
I'll second.
Okay, motion's been made and properly seconded. All those in favor of the motion signify by saying aye. Aye. Opposed? 3-2. So it stays open for another 2 weeks until we have resolution with our absent board members.
And of course, as you know, under our board rules, in the absence of 4 affirmative votes on case number 265, it will be denied by operation of law.
Yes. Okay.
The next case to be presented to the board is one that you've heard from the district council from the district council member already, and that's 2017-160. Involves the property located at 3179 Earhart Road in Council District Number 12. The request is from the appellant, Brandon Williams, on behalf of New Beginnings International Ministry Incorporated, the owner of the subject property. It's a special exception with regard to the religious institutional use in the RS-15 zone property, as well as a variance from sidewalk requirements for the property shown here in the aerial photography. The site plan submitted shows the proposed layout of the church. You've already heard from the council member. However, the appellants will have the opportunity to come forward and make the desired presentation. There is opposition present as well, so they'll have 15 minutes. Those who make the presentation on behalf of the appellant may want to save some portion of that time for rebuttal purposes. Please come forward, identify yourself by name and address, and make your presentation to the board.
I'm Jesse Walker. I'm the engineer that presented the plan. I live at 492 Saddle Drive. This is a request for a special exception, which is a pretty straightforward thing. We have a church with roughly 200 members that are going to meet on Wednesdays and Sundays. So that question y'all were asking a moment ago, we'll go ahead and put that on the table with you.
The other question is, did you send out your letters and did you have your meeting?
We did, and Councilman Glover was at the meeting, but no one else showed up. So we did have Brandon Burnett and Councilman Glover at the meeting. Spent a good bit of time talking with them about it in advance. None of the current opposition showed up for that meeting, but the meeting was held and notices were sent. So the second item, of course, is the request, as you heard from Councilman Glover, requesting that we be granted a variance and not asked to pay the in lieu of fee on the sidewalks. And from a civil engineering standpoint, I want to just say for the record that on Earhart Road, to go in there and build a curb and gutter and the sidewalk that would be required would actually probably create a safety hazard if we did it. So obviously, that's part of the reason the Planning Commission, and plus nothing's ever going to connect, part of the reason that there was a recommendation that it wasn't logical to do it. We requested a deferral at your last meeting after discussion with Councilman Glover because he felt like that what he has presented now as legislation would actually be pending legislation at that point. And as you heard from him, it didn't turn out to be that way. But we're not going to waste your time continuing to move on. We're just going to request that looking at where he's going with this and with the recommendation from planning and so on, that they feel like they're going to move forward with this exception that he's asking for religious institutions on sidewalks, that you go ahead and grant us the variance at this time on that sidewalk and in lieu of requirement. And that's really all we have, other than any questions y'all might have for us.
Okay. Questions of the applicant?
There were several recommendations from the planning department. Have you read them? Some of them were dealing with sidewalks, and then some were other. Would you like to read that?
I have read them, but frankly, we've been through so many deferrals and so on, I couldn't freshly state them.
Could you look it over and see if
Sure.
you...
We didn't have any objection to any of them.
Okay. So we can put that in the record that you don't object to any of them, except for the sidewalk.
Right.
Okay.
Any other questions? So you'll have time for rebuttal to come back. We're going to hear from the opposition. The opposition, please come forward, state your name and your address for the record and why you're opposed to this request.
Hi, my name's Gary Fee. I live at 3174 Earhart Road in Hermitage, directly across from the proposed location.
I'm sorry, I missed your last name.
Fee?
Okay, FEE.
And the light comes on. There you go.
There you go.
FEE.
Thank you, sir.
Hello, my name is Patricia Beach. I have the residence at 3181 Hermitage Road, sorry, Earhart Road. I have the property directly in front of the building that is being planned.
Okay. I'm James Lee, 3187 Earhart Road. I have the property adjacent to the proposed plan.
So, yes.
I'm William Ross, 3208 Earhart Road. I'm about a quarter of a mile away from the proposed church.
So who wants to get us started and why you're in opposition to what they've proposed?
I can start. First, thank you for hearing us. There are several rows of people besides the people up front that are not happy.
They're in opposition here today?
That are in opposition.
So please raise your hand if you're here in opposition to this. So there are 4 other people here that are in opposition besides the 4 that are testifying. Okay, thank you.
And we're all not very happy that we don't really have a say as to whether the church will go there or not. But we are at least happy that we have an ability to say something about the effects on our community as far as sidewalks and stuff like that. It does seem like it doesn't go with our community, number one, and it's like a square peg in a round hole, but you're ruining the whole pegboard. Now, with the church, there's going to be an increase of traffic on a road that already, the reason that all of us bought our houses there is so we could have quiet area with not a lot of traffic, enjoy nature and the wildlife that's there. So this will greatly impact the community as it is. With the new traffic from the church, it not only does it not make sense to say that it doesn't make sense to have a sidewalk there. It should be imperative to have a sidewalk there with the new traffic that's going to be introduced on this road. Also, in speaking with the pastor, he said that they were going to have a community garden. If you're going to have a community garden and invite people in to use it, you absolutely should have sidewalks leading up to this. Also, there's a lot of new subdivisions going up, which will have sidewalks. Even though sounds like there will be variances they'll be given for the building of the building, it doesn't make sense to disallow or to allow a variance for the sidewalks if the church is in fact going to be built there with all the traffic that's going to be introduced. And meeting 2 times a week does not really give an accurate picture. Most churches have activity in the churches every single day, or almost every single day of the week. So just the nature of the road and no shoulders, there needs to be sidewalks there. So thank you. Oh, and I guess one other thing. Well, I guess it doesn't pertain. This will be the 5th church in a 1-mile radius of this area. So, thank you.
Thank you very much for allowing us to speak with you guys today. I'm not sure if you're familiar with Earhart Road, but it is one of the narrow roads that wind throughout this beautiful area. It has no side, no area to have a sidewalk, so there's going to have to be some sort of plan on that. But it's a dangerous road, so if with this garden that is being proposed is available to the neighbors, as they have said, the neighbors, unless they're going to be driving to the church, would probably prefer to walk, and therefore there's going to need to be a sidewalk. There are several issues. I purchased the house at 3181 approximately a month ago. I did not know that the church was going in. My realtor told me that the property had been purchased by a church, but it changed his mind and went away. And the sign out in front had an old date on it, and I honestly thought it was just something else was going on. I didn't know until I spoke with the previous owners. Some of the concerns that I have, and I realize that this is mainly for the sidewalks, which is definitely a needed implement, which will be the watering system that will be there now. The ecosystem will be changed. The possibility of my home being flooded and destroyed with all the water heading down the way. So I'm hoping if this does come to pass that they have a really good drainage system, or I may own that church. We purchased it to be quiet in the city. We came from Colorado, which is really busy and growing, and we came here to try to find a little bit of peace. One of the issues that I do have a question with the Metro Code that states how upstream and downstream water sites cannot be disturbed, but this obviously is going to make a huge difference on where this water is going when it rains or storms. There's animals back there, and we enjoy seeing them. If there's a ditch or something drained, it's going to interfere with their movement. But I guess the main thing right now is getting a sidewalk in there to keep us safe, because that road is dangerous. I can't imagine how many people are going to end up in my yard if they miss the driveway, and it's going to be scary. So at least we need a little bit of protection, so a sidewalk is a very good idea. Thank you very much.
So you're saying the sidewalk might act as a buffer. Do you think people will walk on the sidewalk if
Yes.
it doesn't connect to somewhere else?
It will be on the sidewalk. It just will give a buffer between the road and my home. Not by much, but a little bit.
And remind me, you live how close to the property?
I'm directly in front of it, immediately to your left or to the north of it. My fence is between the church and my house.
Okay, who else wants to add something?
And try not to repeat what was said here there again, but thank you for actually listening to us. The primary concerns that I see currently is where they actually have the driveway laid out is a known flood area. It has actually flooded their house 3 times already. So obviously that's not my house, so that piece from a house standpoint. But as she said, when they start messing with the water runoff, I expect my property will become also the natural result of that flooding. That piece concerns me. I do know there was a sinkhole somewhere that was filled in that driveway area that used to operate somewhat as a drainage area. Since then, they actually filled that and tried to cut a couple of ditches through to drain the property. So that's the first piece I have. The mention of the traffic. Right now, it looks like they're looking at somewhere between 100 and 300 cars, depending on whether you assume there's 3 people per car or 1 person per car. We've already had a couple of wrecks right there in that curve. The last piece that comes of concern is we're currently experiencing water pressure issues in the area anyway. So I don't know, I haven't seen any plans Metro has for improving that water pressure in the area. So I don't really see the infrastructure upgrades occurring to support a 300-person church. And actually, I apologize, I missed it. The last one that's a concern, and I don't know where this falls in it, but from my understanding, the minister has made comments that he intends to put a halfway house in. So that's of a great concern to me with a 17-year-old daughter as well. I don't know what kind of restrictions exist. If it's only a church, that's a different thing than it's a church with a halfway house in there as well. So anyway, there again, I do want to thank the board for listening to my concerns.
Well, I think it's pretty obvious that we don't know what exclusions apply to a church versus a non-religious institution. One of the concerns I have supporting the people that are here with me is that the signage that alerts us to changes is virtually impossible to read. It's set up very close to the, not this lady's property, but the far property in an area where you cannot pull a car over to read it. And in the past, people that have looked for variances have posted very clear signs. So we depend on people like Gary to go across the street and read the sign and then alert the rest of the neighborhood, which I don't think is proper. So that's my big concern, and I just want to be assured that when the property is being built, that building codes apply to a church just like they do to any other building.
Also, that sign hasn't been maintained. It didn't contain the correct date, didn't contain today's date. And I want to bring clarification to the notification of the meeting that was claimed that people did not show up. We received a couple notifications. One was a zoning appeal notice, neighboring owners, and it told of the initial meeting, which was back in July, and said that if you wish to show support or opposition to your neighbor's request, you may do so in person. So this talked about coming here. We showed up here, and it was immediately deferred. There was another notice that talked about coming to the New Beginnings International Ministry, did not say anything about a councilman being there or showing approval or opposition. It just sounded like a meet and greet. We're coming, and come and show up and meet us. So clearly, with these two notifications, there was no way of understanding anything differently than show opposition, come to the meeting here, which we all did, and then this other thing about, hey, we're coming to your neighborhood, come meet us. So I wanted that clearly stated so you guys understand what truly happened. Also, with the new communities coming up, there are many sidewalks that are being put in. We don't want a few years down the road where there's just exceptions that were granted today that are now spaces in a contiguous sidewalk, whether it was a religious institution or not. And everyone here has their own churches. We're not opposed to churches. We just want to hold as much of our community as we can to the same standards that we've had of it and not see it deteriorate in front of our eyes without a word.
Questions?
We'll have a couple of comments regarding building codes. They'll need a permit, and inspectors will come out and inspect the work. And before they can occupy the building, inspectors will come out from code. So the building will have to be code compliant. And I do have a question about the letters for the community meeting. Are those letters written by the applicant themselves and given to the codes department to mail, or is there a form letter?
Yeah, the community meeting letters are just a form letter. It looks the same from the case you heard previously to this one to the next one that's a special exception case. And they are, of course, only on special exception cases, not variance cases, and that's a matter of board rule.
Okay, so they should have received a letter that was official looking from Metro Codes that that told them to come to the community
It's not sent by Metro Codes. It's sent by the appellant, of course. But community meeting is all we ask of people to go and participate. Typically, we encourage them to incorporate their district council members as well. Some council members always participate in those, some when available, and others just generally don't. But nevertheless, we encourage people to work through their council members on those.
Okay, and then the signs, I'm pretty sure I understand they're not required to change the date from the original hearing. That's not a requirement, right?
They're encouraged to do so. The docket, of course, speaks to the fact that, as is the case today, I think there are 8 or 9 of the cases on today's docket that have been deferred from prior dates, so there's always going to be that kind of scenario. Some appellants do a better job than others of running out and changing the date every single time it gets deferred, but nevertheless, our primary interest, and not the law's primary interest, is making sure that nearby neighbors are aware that there is a hearing coming. And of course, we at the Codes Department field calls, emails, and visits all day long, 5 days a week, responding to questions like those about upcoming cases.
And just to chime in on the deferral, as with today, typically they are deferred to a date certain. So that's an additional notice. Even if the applicants do update their signs, there's also the notice that's given at the initially scheduled date.
Any other questions? Do you have any? Are you in opposition?
Yes, I have photos of the sign. Come forward, please.
Please come forward and sit at one of these so we can hear you, and identify yourself and your address for the record.
My name is Tim Davis, and I live at 3196 Earhart Road in Hermitage. I'm very close to the property in question. I have pictures of the signage that was put up, several pictures, and the sign itself was put beside a fence, and I can pass this around to you, Mr. Chairperson. And it was covered in plastic. And it was not properly
The
displayed.
sign was covered in plastic, or the
Yes.
fence?
Yes.
What, clear plastic?
Yes. I can show the pictures. You cannot see it from one direction at all. And it was fronting the street, not normally as they put them perpendicular to the street, so people on both sides can read it passing, north and south.
So it was parallel to the street?
Yes, sir.
So,
and I do have several pictures. I made 2 calls, and I just got voicemail when I called about this.
So John Michael, why do we put these signs out, and how does one put out a sign? Are there any rules?
To the implied question of whether the law specifies geometrical orientation of the notice sign vis-a-vis nearest roadways, there is no such specification under either the zoning code or the board's rules. However, as you know, under the zoning code, the purpose of putting out the signs is to provide immediate location-specific notice to passersby or certainly neighboring property owners, so they have an opportunity to learn more about what the case is, come to the hearing if they wish, be at least advised that it's a BZA case, the number of the case, the date of the original hearing of the case, and some very simple description of the case, a special exception, a variance, whatever it may be.
And we do have 8 people here in opposition, and obviously the council person is aware of this case because he also spoke about this case at the beginning of the meeting.
And you heard, of course, from the neighbors that they had many other people who came with them to other dates that this case was originally set.
Mr. Chairman, one more thing.
Yes.
Thanks for listening to us, but our councilman has not met with us at all about this. They proposed a meeting, and it was not made like he was going to be there at all. We have voiced our concerns, and he has not met with us. And again, I have photos of the signage if any member wants to see it.
But you didn't attend the public meeting?
The first meeting that the letter went out?
Yes.
No, I did not.
Okay. Any questions from the opposition about this? Okay. Anything else to add? We're going to hear from the applicant again. Please come forward. And this is rebuttal testimony, so you could respond to what you have just heard and tell us why you picked this location and why you want an exemption from the sidewalk.
Well, first of all, certainly the letters were compliant and exactly as we were asking in form and format and so on. There's nothing in the letter or the format that allows you to say that the council person is going to be there, but nonetheless he was. It's pretty clear to me if we've got 8 people here in opposition that the neighborhood knows what's going on and that they know when this meeting was going to be and when the other meetings were going to be because they've been here at other meetings. So I really don't think there's any question about whether they've gotten adequate notice. That said, I did not hear that they had any information from a traffic expert or a traffic study that was going to really indicate exactly what the nature of the hypothetical increase in traffic was. I've been assured by the pastor there has never been any plan and never been any mention by him or anyone else about anything to do with the halfway house. That's somebody's idea of some rumor to try to get something going on. I guess I don't really know. I think it's interesting that they state themselves that there's 5 churches in the immediate area, and yet the beginning of their whole presentation to you was that this was an out-of-place thing and very strange for their neighborhood. None of those 5 churches certainly have any sidewalks, which I think is the primary issue here. The garden is going to be in the rear of the property, so anyone that enters is going to be walking pretty much a half a mile to get to this garden unless they bring their car and drive on in back to where the garden is. So I doubt we're going to have a lot of foot traffic that's going to walk quite that far to get to the garden. We will meet all drainage and ecological requirements, of course, as stormwater would require, and most likely, based on the stormwater requirements and so on and the situation there, most likely we will actually improve what's going on drainage-wise. So the drainage concerns they have, I'm the civil engineer that's going to do the design, and I am sure that once we've complied with stormwater, we will be placing a detention area, I'm sure, and some rain gardens and so on. So I don't think there's any adequate concern about extra runoff. Certainly quite to the contrary would be the more likely situation. So they're telling us already that there's numerous wrecks, and I, as a traffic expert, have testified before this board that I think that the placement of this one little piece of sidewalk and a curb and gutter there would be likely to create a traffic hazard rather than creating a good situation that made this safer. And I'm saying that to you as a civil engineer with a specialization in transportation. So,
Typically address the neighbor across the street's concern. She felt like a sidewalk would create some kind of buffer.
Actually, I believe, if I understood correctly, that she lives in the out parcel that you see at the front of the property there. If I got it right from, she said across or in front of the church, but if you notice this out parcel right there, it has a different owner's name on it because at the time this map was made, someone else owned it and they've sold it. I believe that's what she has bought, is this house there in the front, and the sidewalk's not going to extend in front of her property. We're not being required to do that, so I don't know that it's going to really provide a buffer for her as such. So, any questions?
Yes. Anyone have any?
Yeah, we do have a comment from Public Works that seems to be a safety issue, and I wanted to see if you would agree with this. It says, Public Works takes no exception with condition that adequate site distance is provided at driveway and Earnhardt Road, and adequate separation between Church Drive and Residential Drive is provided.
Right. Yeah.
Any other questions?
Just to review, we did ask about the recommendations from planning, and they are recommending that we approve the sidewalk variance with the condition, among others, that you pay into the in lieu fee. Is that agreeable?
Well, we would prefer not to pay the in lieu.
Well, obviously, we'd prefer not to. But
we'd prefer not to pay the in lieu fee, and they're making that recommendation in keeping with our normal situation, but they're not making that recommendation in terms of that being a good planning perspective per se. And I would refer you back to the councilman's pending bill in that regard. I mean, that's where we are on that. Should you choose to go forward and give us the special exception and not give us the sidewalk variance as far as paying the in lieu of fee, we would certainly be satisfied with that, but most likely if his bill passes, we'd probably be back before you asking for the variance at a future time.
Okay. Anything else? Thank you. We're going to close the public hearing. And before we get started with our deliberation, I have a question for our general counsel, our lawyer. remind us about the Tennessee Religious Freedom Act and the federal act that goes along with it and the establishment of churches in residential zoning areas.
Those laws ultimately prohibit zoning laws that would substantially burden the free exercise of religion. So if what is being asked, you look at that when what is being asked goes to their core mission, fundamental mission, and if it would substantially burden the exercise of that mission or that religion.
And that applies to what institutions?
Religious institutions.
Okay. Okay, deliberation.
Well, the department take the position, just so I understand it, that just simply denying a special exception as to this parcel of property infringes on that exercise of religion.
I think if they meet the requirements the requirements for a religious institution under the special exception code, then it should be granted.
So we can vote separately on the special exception versus the...
Yeah, we could vote on the special exception and then separately on the sidewalk variance request. So, deliberation.
Well, I think the law is clear as to the religious exercise of religion. And while I think it is unfortunate that it requires oftentimes for churches to be built in areas that probably you wouldn't necessarily expect to have a church, I don't think that we can fly in the face of that settled law. I think the grounds for a special exception for religious use have been met based on what we've heard.
So your motion is to yes on the...
I'll make it a motion. I move that we grant the request for special exception for religious use.
Okay, motion's been made. Is there a second?
I second.
Motion's been made and properly seconded. Any more discussion? Seeing none, all those in favor of the motion signify by saying aye. Aye. Opposed? Passes unanimously. Let's talk about the sidewalk variance request.
I have a question about that request, and I think I'm reading these recommendations wrong, perhaps. On the planning department recommendation, it says, if you look in the analysis, it says number 1, that this property is ineligible for the in lieu fee because it's on a street captured by the major collector street plan. So what is that? And then down it says, then it recommends that we pay the in lieu contribution for the property.
I think that means that they can't, of their own volition, choose to pay the in lieu fee instead of, but we can make it a condition.
Okay, I just want to make sure.
Does that sound right, staff, lawyers over there? Okay.
Can I jump in there? Because I had that same question last night, and I noticed there was an updated recommendation from the planning department that said something different.
Note that the original recommendation from the planning department had to do with the special exception, which of course they provide to us on any special exception case with or without a sidewalk variance request. However, because there was also the sidewalk variance request, and planning also provides a recommendation to the board on those specific cases, it just so happens that the sidewalk issue was discussed in both of those recommendations. Wasn't so much of an update as just a more focused approach on the latter.
I have a letter from them on July 20th and then one on September 7th, and the conditions are something different on September 7th. So I took it that we should go by the conditions if we choose to go by them from the latter letter. Is that this one? See, I saw this. This one is September 7th, and then you're right, there's something else that we got too. It's a little confusing.
But I think ultimately they're making the same recommendation. The recommendation in the special exception memo, I believe, is they're saying we'd like them to build the sidewalk, but if they're not going to build it, please pay the in lieu fee. And then when they address the sidewalk specifically, they're saying please make them pay the in lieu contribution. They really don't need to do the sidewalk.
Yeah, to me, I mean, okay, councilperson comes up here, says he's filed a legislation in front of planning to exempt institutions like this of religious nature from this new sidewalk bill. So, but the law says basically, given their location, they don't have to pay in lieu fund, but their recommendation to us is make them anyway.
No, my interpretation is that they're not allowed to choose to pay the in lieu fee on their own, but
Right.
we can. In other words, they have to build the sidewalk or
They
get a
can't.
variance.
Okay, they can't just get out of it by
Yes.
paying in lieu. Okay, so what do we think about that request?
Well, without getting too much into the legislation, because I haven't seen it, I don't know that it's appropriate to have such legislation that, excludes.
They are the legislative body.
But, until then, when that's the law, I would be more than happy to follow. But until then, I'm not really interested in giving any special weight to the sidewalk for the use of the building for the sidewalk. So I will move, if you guys are ready to entertain it, that we grant the variance for the sidewalk with the condition that the applicant pay the in lieu fee for the frontage.
I'll second.
Motion's been made and properly seconded. Any more discussion? Seeing none, all those in favor of the motion signify by saying aye.
Aye.
Opposed? 1. So passes 4-1. John Michael, it's probably a good time to take a short break.
The board will take a short recess and then reconvene with case number 205 thereafter. Located at 312 Clark Hill Crossing, shown here on the zoning map just off Cedar Ash Crossing. Front of the property from the assessor's website, a dated photo, and then the aerial of the neighborhood in question. You've already heard from the district council member, Ms. Dow, with regard